issues regarding the coordination of current UNIDROIT and UNCITRAL projects in particular, covering secure transactions or also covering secure transactions with the existing international framework, and particularly the instruments already adopted by the two organizations. And we have already heard some very stimulating and important comments regarding some of those projects that I hope our panel will be able to take into account. The projects we are going to discuss are four in particular: the model law on factoring, the digital assets and private law project with specific regard to security rights on digital assets, which is part of that project, the project on best practices for effective enforcement, again, as far as it touches upon the enforcement of security rights, and the work conducted by UNCITRAL on access to credit for SMEs. And as there will be, as you know, a special session on agricultural financing, then we will leave out the model law on warehouse receipts and other current projects that are more tailored to the agricultural sector, and I think they will be considered tomorrow. Before giving the floor to my very distinguished panelists, and I'm very happy to have at least two of them here in the room, and the others are participating online. Let me just add two very short considerations that might feed the discussion. The first is probably a point that has been raised from an institutional point of view and a process point of view. We see that in the projects that I have listed, there is a tendency to develop instruments that are guidance documents, soft law guidance documents, especially tailored to legislators, even if not only to legislators, that are, however, different in their form and also in the degree of granularity. And this depends on the subject matter. And it might be one element to be considered when talking about coordination with the existing legal framework. And a second point, and here I'm really abusing my position now as the moderator of this panel, because I was deprived of the possibility to make a comment in the first panel, and this is the comment that I wanted to make. And the comment is this one. So I think a very good point was made that existing current projects which are developing actually are based on the big shoulders of existing best practices. So the idea is to develop on the basis of what has already been achieved and not to contradict what has been achieved. And this is perfectly true. At the same time, because of the purpose and the subject matter of some of these projects, there might be also the need to give guidance to legislators in legal systems that might not yet have reached the full potential, let's say, of existing best practices, and therefore to try and give effective solutions also for these systems. And this is not easy to do, not easy to achieve, but it is something to be taken into account also in terms of, I think, of coordination. So all this, of course, will be much better discussed by my panelists. The idea is that we will hold a first round with each speaker. Each speaker will intervene for a maximum of 10 minutes, focusing on the following question, and you will not be surprised by the first question. The first question is, how does this project relate to or coordinate with existing instruments, particularly of UNIDROIT and UNCITRAL for this panel, dealing with secure transactions? And what is, and this is important, the added value of the project against the backdrop of the existing international legal framework. So the first, we have actually 3 institutional speakers for this panel. And then we have 2 academic speakers who are and have been heavily involved in the work of both organizations. So I will start with my very dear colleague, Will Brydie-Watson, and for many reasons, he could talk about many of these projects, but I would ask him to concentrate on the model law on factoring and answer this first question. You have 10 minutes, Will. Thank you.
Thank you, Anna, and good morning, good evening, good night to everyone following from around the world. It's my absolute pleasure to be here to present at this 5th Secure Transactions Coordination Conference and speak briefly on the UNIDROIT Model Law on Factoring, which is currently in development. I think for this forum, the most important starting point to understand how the future model law on factoring will fit into the broader international secured transactions legal framework is to discuss why it was proposed to UNIDROIT in 2018. So in 2018, UNIDROIT received a proposal from the World Bank Group for our 2019 to 2022 work program to develop a model law on factoring. And this was because the World Bank Group, in working around the world and implementing secure transactions reforms, had identified a specific need, a specific gap in relation to factoring reform, despite the fact, as you all know, there are actually a lot of international instruments in the field of assignment receivables that already exist. So to explain, we have, the first was the 1988 UNIDROIT Convention on International Factoring. Then we had the 2001 UN Convention on the Assignment of Receivables in International Trade. And then, of course, the 2016 UNCITRAL Model Law on Secure Transactions. Now, what was explained to us is that in relation to these 3 instruments, none of them quite fitted what was needed in providing specific tailored guidance to states in relation to the development of a domestic framework for factoring, for very simple reasons. Firstly, the UNIDROIT Convention on Factoring is tailored to international factoring between parties in different countries. Similarly to the UN Convention on the Assignment of Receivables, also tailored to international transactions, not domestic transactions. So then, of course, you have the 2016 Model Law on Secure Transactions, which absolutely does provide a framework for factoring, but it provides much, much more. It provides a fully comprehensive regime for the financing of assets, for the registration of assets, for priority in assets, which is fully uniform and is absolutely best practice. But what was discovered in the field is when countries were asking for a particular legal framework in relation to factoring, when the suggestion was, well, you should implement the model law on secure transactions, a lot of them weren't ready for a comprehensive reform of that magnitude to go through all the different asset classes that the model law on secure transaction provides. Hence, there was a proposal, we need to develop something more tailored to this particular field to address this gap in the international legal framework. So I think that sets up very clearly why we worked on this project and how hopefully, if successful, how this future instrument will fill it. So essentially, from this basis, there are 3 policy requirements, somewhat competing, that the future model law on factoring has to fulfill. First, it has to provide a standalone, comprehensive, fully formed framework for domestic factoring. So, enough to start to finish covering all the different parts of a factoring framework, allowing for creation, transfer, registration, priority, enforcement, conflict of laws, transition. So it needs to be standalone. It can't be incomplete. 2, it has to provide, and it has to be integrated into the other broader instruments, in particular the model law and secure transactions. So it serves as a first step towards broader reform. So when a country says we're not ready for the model law and secure transactions, but we want a model law on factoring, if they implement the model law and factoring, this won't then create a barrier to future reform or additional complications in relation to future reform. So it has to be standalone, but also provide for future integration to broad secure transactions reform that many people in this room are working on. And finally, it has to be shorter and simpler than the model law and secured transactions, because if it's just as long as complex, then you're not going to have the uptake because you're going to fail. You're going to meet the same kinds of barriers and the same kinds of pushback you get from states who say, look, all we want is a better factoring framework. So these were the three challenges that we were facing when this project was put on the UNIDROIT work program in 2019. Now, to deal with these challenges, as most of you are aware, the UNIDROIT working methodology is, in many cases, as referenced by both Ignacio and Angelo, is almost a best practice in coordination, in that we bring together a working group of experts representing different civil law, common law jurisdictions from all around the world to negotiate the instrument, and then give standing to essential stakeholders and as well as the private sector. So in particular for the model law and factoring, we created a working group of 10 experts comprising of people from the United States, Italy, Canada, Slovakia, Argentina, United Kingdom, Japan, and Australia. Our partner observer organizations on the project are UNCITRAL, the World Bank Group, NatLaw, EBRD, OAS, the Afro-Exim Bank, and OHADA. And also, essentially, we include the industry groups that will actually be using this model law and promoting this model law around the world, in particular the FCI, the ICC, World of Open Account, and the Secured Finance Network. So we have a very inclusive process, a very transparent process. We allow anyone who's interested in the field to participate, to observe the meetings. All of our documents are available online. And this in at least, as Ignacio said, there are many different levels of coordination. In terms of the coordination of the development, the legislative development of the instrument, this has worked very, very well, and why we're confident that this project is I hope, modestly put, is on track. So, and the other essential element of including these different organizations in the development is that involving people like the IFC, the EBRD in the actual implementation is that it gives these organizations who will later go on and assist in the implementation of the instrument, it gives them prior notice that this is coming down the line. Because if they are setting up, multi-year secure transactions reforms in different countries, they need to be aware that this new international instrument that reflects best practice is going to be available. So it's not just to make sure that we include their expertise in the legislative development itself, it's to put the world on notice that this is coming down the line and should be taken into account in planning secure transactions reforms, which, as you all know, is a very long-term process. It's not something that's done overnight. As noted earlier, this is not a technical forum, so I'm not going to go through the 54 articles and 25 registry clauses in the draft model law itself, which I'm sure you're all very happy about on a Tuesday afternoon. I did want to note two rules in particular that I think are important even at this broader level to acknowledge, and that is one that was easy to resolve and one that was hard to resolve. The hard issue was scope. The working group grappled for 18 months on how exactly to fit the scope of the model law and factoring into sort of the broader framework to make sure it covered comprehensively factoring but didn't go too far into other transactions. Essentially, the scope is, it applies Article 1 to F of the draft model law, sets that it applies to receivables and defines receivables as contractual right to payment for a sum of money in relation to goods and service provision or lease of goods and services, number one. Number two is the license or assignment of intellectual property. Number three, representing the payment obligation of a credit card transaction. And number four is data receivables, which is an area that we need to cover but haven't quite yet got the terminology right for. It covers both outright transfers and the creation of security rights in receivables. It covers current and future receivables and covers both domestic and international factoring. That's what it covers. Of course, that's sort of how we confine the scope. We further confine it by excluding a few things. Doesn't apply in relation to receivables for removable property, doesn't apply in relation to certain financial receivables of intermediated securities, and doesn't apply to negotiable instruments or bank accounts except by way of them being proceeds of receivables. So this is much broader than the scope of the original UNIDROIT Convention on International Factoring, but much narrower than the scope of the model law on secured transactions, obviously. So we think we've got somewhere between a very narrow and a very broad scope. We think we've got the scope about right, and that's the feedback we've got thus far on the draft instrument. The second point that was much easier to negotiate, but is, in my view, equally important, is that it enshrines the creation of a registry for perfection and effectiveness against third parties of a notice-based registry for transfers. Now, this might seem non-controversial to most people in this room, but of course, if you look at the history of these types of instruments, the Factoring Convention didn't provide for the creation of a registry. The UN Convention on Assignment of Receivables provided it for one option in its annexes of several different options for perfection. And of course, the model law on secure transactions did provide for it. So this very much continues the modern trend of registry-based secure transactions reforms. And as I said, non-controversial, but really important, because if the model law on the model law on factoring is going to be the first step towards a more comprehensive reform, it needs to be registry-based. And if it wasn't registry-based, it would have caused a huge problem if you were trying to then transition to the model law on secure transactions. There's also been note that in those states where they go model law on factoring and then secure transactions, we should use the same registry. You don't want a proliferation of different registries. So to conclude, I set out three objectives at the start of what we were trying to achieve. A standalone model law, which we think we've got because it reflects all 9 chapters of the contained in the model law on secure transactions, just shorter. So we think it's standalone. We think it's comprehensive. We think it covers everything. Second is broadly consistent with the model on secure transactions, and on the major things we do, we have tried to reflect those standards and make sure that it does serve as a first step towards a broader reform. And 3, is it simpler and more concise? And that's the most objective thing we can measure. Yes, it's the draft model law is approximately 9,000 words as compared to the model on secure transactions, which is 25,000 words. So it's essentially 2/3 shorter. So we're hoping that will make it attractive and digestible for enacting states as a first step towards broader reform. I've got about a minute and a half over. Apologies for that. I hope that was helpful.
Thank you very much, Will. I think I will not bother you with the 1 minute overlap, but I will then directly go to the next speaker, and then we can have a discussion afterwards. And the next speaker is actually online, and it's somebody I don't need to introduce either, Professor Louise Gullifer. So she is was involved in a number of projects, both at UNIDROIT and UNCITRAL, but today I will pose the question on coordination and added value with regard to the project on digital assets and private law as regards secured security rights and secure transactions. So Louise, you have your 10 minutes floor.
Thank you very much indeed, Anna, and good morning, good evening, good afternoon, whatever it is to everybody. It's lovely to be able to join you. I'm sorry I can't be there in person, but we have just beginning term in Cambridge and I'm having to talk to students and to do that kind of thing. So I'm going to tell you just a little bit about the project so that you can see what we're talking about. And then I'm just going to consider a little bit about the secure transactions provisions of the project and how it interacts with basically the UNCITRAL model law on secure transactions. So this is a project to formulate principles for the private law of digital assets. And I mean, it's perhaps obvious to everyone here that we're talking about private law and not regulation, because that's what UNIDROIT does, but it really isn't about regulation. It is about private law, and that's the first thing to remember. Next thing to remember is, and this of course is immensely difficult, that it's meant to be technologically neutral. As I think it was Geraldine who said earlier, we try and make it technologically neutral. That is very difficult in this area, but the way that everything is phrased is that we have made it technologically neutral. The only thing I would say is quite a lot of our commentary gives examples of current uses of blockchain and DLT, because those are the examples of the types of digital assets that what we define as a digital asset that are around at the moment. Thirdly, of course, it is meant to be legal culture neutral as well. Again, a great challenge, but it is, because these are principles and they are quite high level, they are largely drafted in a functional way, and in a way that is supposed to be able to click into any particular legal culture. So they are quite high level for that reason. Some of them aren't. So what we've done is, basically, this is not a complete code. It's nowhere near a complete code, not just because it's not drafted, it's drafted as principles, but because the idea of the project was to identify principles that were needed in relation to digital assets, which weren't part of normal domestic law in a state. And we're talking largely about property law. We're not really talking about contract law, except in one or two very specific examples. So we're talking about trying to identify what principles would be useful for states, partly to harmonize the law, and also just to be useful to states to make sure that their own law complies with what we would suggest is best practice or best principles in relation to digital assets. But as I'll explain in a minute, there is an awful lot of issues that could arise in relation to digital assets that we say are not covered in the principles because they are covered by what we call other law. So the principles include consisting of some specific rules, relatively few, probably about, 10, 12 specific rules, where we consider this is necessary to reduce legal uncertainty. Then there is supporting legal analysis for these rules, and some of that is the most important work that we're doing, the definition of digital assets and the definition of control, for example. And I think, so it had been said, we say a digital asset is an electronic record that is capable of being subject to control as we define control. And control is a very clearly defined concept. It's a factual concept clearly defined in the principles. It is very necessary to do that because it is also part of the definition. In other words, there are lots and lots of electronic records which do not fall within our definition of digital assets. And it's the being capable of subject to control that is the that bounds that definition. Then we have several principles making it clear what is not included in the principles, what is left up to other law. And other law is applicable law, which is that other than the first two, the rules and the supporting analysis. So to give you an example of that, we say, and this is what I mentioned earlier, that we say, okay, so the digital asset is the electronic record that is capable of being controlled, but that record can be linked to any other form of asset, for want of a better word. So a right, a claim, a piece of tangible asset, anything. And the link may or may not be effective. It may or may not mean anything. It may be merely a link that the issuer, whoever it is, thinks they've created, but they haven't created it under whatever the applicable law is. It may be an effective link. We don't know. We say this is up to the other law. It's up to the applicable law, and it's nothing to do with us. So it may be that a state's law says that, shares have to be registered in a share registry that is held in a particular place. And so you can't link a share to a digital asset because transfer of the digital asset would not transfer the share because it wouldn't be registered in that registry. And that's really nothing to do with our project at all. We do give quite a lot of guidance in the commentary as to the types of issues that might arise because we just thought that might be useful. And then, and as I said, we've got commentary, and the commentary is reasonably discursive, or it will be when we finish it. The idea is that the commentary is there to give guidance as to issues that can arise in relation to other law and areas that are not covered by the principles. We don't give guidance as to what the answers are because that depends on what the law says, but we give guidance as to the issues that could arise. So we have a set of principles, and I see it as a sort of checklist for states. So it isn't necessarily the case that we would say that a state needs to legislate in a particular way, they need to say, well, have we already got these principles in our law? And if we have, we don't need to do anything. And if to the extent we haven't, states need to consider whether they need to bring in legislation or change their law in whatever appropriate way is appropriate for that state. Now, it's a general project. It covers all kinds of things. And I'm just going to talk about the very few principles that relate to secure transactions. But perhaps I should suggest that so secure transactions are, if you like, in terms of our project, a kind of subset of the very first principle, which says that digital assets can be the subject of proprietary rights. And that possibly would have been enough to, as it were, deal with the first principle we have on secure transactions. But we've actually said that secured digital assets can be the subject of security rights. And this principle is incredibly important because there's a lot of uncertainty in many states as to whether this is actually the case. So how does this link in with the UNCITRAL model law and secure transactions? Well, what we couldn't do, and this links into what Anna said earlier, what we couldn't do, well, as you didn't feel we could do, is to say that the principles on secure transactions in the digital assets principles will only apply to a state that has adopted the UNCITRAL model law or has a consistent secure transaction system, because that really would, as a matter of practice, mean that there are lots of states that just wouldn't be able to engage with our principles at all. So what we have said is that two things. One is that it's because the project is legal culture neutral, then the principles on secure transactions will apply or should apply whether or not there is a reform system that is consistent with the UNCITRAL model law. However, we've tried to make sure that the principles themselves are consistent with the UNCITRAL model law. So the principles we have are consistent with that model law, but they will also, we would say, fit into a system that is not consistent with the UNCITRAL model law. So when I've explained what they are, you'll probably get that a bit better. So the first one is very straightforward in a way, because it says that digital assets can be the subject of security rights. The only disjunct, if you want to call it that, is that, of course, if a system hasn't adopted the UNCITRAL model law, then they may see what a security right is as something different from the way it's defined in the UNCITRAL model law. But we couldn't really see any way around that. We thought it was better to have some principles that applied to states that hadn't adopted the principal model law and said, you have your own definition of security rights, and that's what applies here. Then that's basically the only way around we could work it out in order to enable our principles to apply it widely. Then we say that if a digital asset is linked to another asset, then when the security right created over the digital asset extends to the other asset is a matter for other law. So that's the point I've already mentioned. So that's really saying that's what we're not dealing with. So the two main principles that we have developed so far are to do with making a security right and a digital asset effective by control. And because of the nature of the asset, and I should reiterate that the idea of our definition of control is to do with what a digital asset actually is, then we would say that it's important to use that definition of control. And we say a digital security right and a digital asset can be made effective by control and will have priority over a security right made effective by any other means. And both of those we say were consistent with the UNCITRAL model law, not necessarily with every type of asset, but with certain types of assets that are such as documentary intangibles and those which are traded on markets. We also are going to have a principle on enforcement of security rights over digital assets, but I don't want to say anything about that because I hope Neil may talk about enforcement more generally, and we haven't fully developed that principle yet. Now, I think I might have used up my 10 minutes, so I think I'll stop there, and if anyone's got any questions, then we can deal with them later. Thank you.
Thank you very much, Louise. I think we can already see that though the two projects actually in the end respond to something which is common, which is filling in gaps or perceived gaps of the existing legal framework, then they have to deal with coordination in different ways because of the different subject matter and because of how they want to approach the subject matter as regards the way the legislator would look at this instrument. But I'll stop here. I don't want to take time off what Neil will say. So Neil is also connecting online. Neil, are you with us?
Yes, I am.
Okay, thank you. So again, no need for introductions. Neil is active in and was active in many UNIDROIT and UNCITRAL projects. He will. I will ask him to limit his remarks in this first round to the project on best practices for effective enforcement. And then, of course, there is the possibility in the second round to comment on the other projects as well. So, Neil, you have the floor.
Well, thank you, and good afternoon to everyone in Rome, and good morning, good afternoon, or good evening to those who are attending remotely. And I apologize for my inability to attend this very helpful and useful meeting in person. Thanks also to Anna for your introduction, and to Ignacio for setting the table for the discussion of the best practices for effective enforcement in your remarks. The best practices for effective enforcement project, I think, is one that in many ways flies under the radar a bit for people who are interested in secure transactions. Indeed, if you go to the UNIDROIT website and you click the link for secured transactions projects, you won't find it there. And if you click the link for contracts projects, you don't find it there. It's listed under civil procedure. Now, this is entirely appropriate in light of the historical antecedents for the enforcement project, going back at least as far as the joint project between UNIDROIT and the American Law Institute on transnational rules of civil procedure, and projects that have followed that. And enforcement is a key aspect of civil procedure. It's a key aspect of any proceeding where one is trying to collect money that is owed to one, whether it is on an unsecured or a secured basis. But enforcement concepts, enforcement rules are critically important for a secured transactions regime. Much of our work in secured transactions, now for over 2 decades, has been based on the shared understanding of the role of what I call the secured transactions bargain in enhancing availability of credit at lower cost. And that secured transactions bargain, of course, is in a sense, the dual promise of the obligor, of the debtor. The debtor gets credit from the creditor, promises to repay the credit, and also agrees that upon default, the creditor will have access to the specified assets of the debtor and be able to get those assets and apply them to the debt. And it's this second part of the secured transactions bargain that, as we all know, that lowers the risk of loss for the creditor and makes it economically feasible in more cases to extend credit and to do it at lower cost. But of course, none of that works if the secured credit bargain can't be enforced efficiently and effectively in a way that enables the basic concepts of the secured transactions bargain to, in fact, increase the availability of credit at lower costs. So enforcement is critical for secured transactions, but in fact, secured transactions are not the sole focus of best practices of effective endorsement. In fact, in some ways, they are an easier portion to address in this project because of the existence of the UNCITRAL projects, particularly, although not exclusively, the model law and secured transactions that deals with this in some length, and of course, the legislative guide that preceded it. So given that enforcement of security interests and security rights is dealt with quite forcefully and if not extensively in the model law on secured transactions. One might ask, what is left of the field for the project on best practices for effective enforcement? And I think what's left is recognizing that the best practices for effective enforcement project starts from a different point and starts from a different orientation than the enforcement provisions in the model law on secured transactions. The enforcement provisions in the model law on secured transactions provide a set of enforcement rules that assume the existence and enactment of a substantive regime governing secured transactions that is consistent with the model set forth in the model law on secured transactions and developed in the legislative guide. While the aim of best practices for effective endorsement is not that narrow, it's not limited simply to recommending enforcement practices for those who have adopted a substantive secured transactions regime, that has been reformed along the lines of the model law. And the second big difference is that the best practices for effective enforcement project is not limited to movable assets. The model law on secured transactions deals with movables, but not immovables. But as we all know, that if anything, across the various states of the world, debts secured by immovable assets are more common than those secured by movable assets. And so the best practices for effective endorsement will address both types of assets. But for purposes of coordination, let's focus for a few moments on the recommendations of this best practices product with respect to enforcement of security interests or security rights in movable assets. As has been pointed out already by others and by me, the model law on secured transactions already provides rules in this area. What's the fate of those rules in the best practices project? Well, right from the beginning, we established an operating principle that that recommendations in the best practices project had to be consistent with the model law on secured transactions. I think the phrase we used was that there would have to be an exceedingly persuasive justification to differ in any way from a recommendation in the model law on secured transactions. I don't believe that standard has been met yet. A couple of times, as I'll explain in a few minutes, we've gone beyond that a bit, beyond the model law a bit, but we have not differed from conclusions. What we have done, though, is in some important ways differ in the presentation of those conclusions. Recall that the best practices for effective enforcement is not limited to states that have reformed their secured transactions law in line with the UNCITRAL model law. It's not limited to making recommendations to states that are considering generally reforming their secured transactions law. It's the readership of this document consists of any state that wishes to enhance its enforcement regimes. And so while the recommendations themselves, particularly the recommendations with respect to how a secured creditor can get possession of tangible collateral and how it can dispose of the collateral, are consistent with and stated very similarly to, if not identically to, the model law on secured transactions, the accompanying materials are somewhat different. What we've done for each provision is to commit ourselves to have three types of commentary with respect to each of the rules from the model law. And the commentary will provide an explanation of the rule, will provide a justification for the rule, and will provide an illustration or more than one illustration of the rule. The theory is that to the extent that we are proposing an enforcement regime that can work not only for reformed substantive secured transactions regimes, but also for secured transactions regimes as they exist now, there's a greater burden of explanation, justification, and illustration of how the rules work. And so that's one big difference in the presentation, not in the core black letter rule itself, but rather in the surrounding commentary. One other big difference, as I mentioned earlier, is that we're going to be addressing, at least to a limited extent, enforcement of security rights in immovable assets. The extent to which we can identify principles that have wide acceptability across a variety of legal systems is still a work in progress, and I'll certainly keep this group informed. Another difference between the presentation in the model law on secured transactions and the presentation in the enforcement project is that the model law deals most forcefully with extrajudicial enforcement, extrajudicial methods of obtaining possession of the collateral from the debtor, extrajudicial disposition of the collateral, and the consequences of disposition. Those rules are good. Those rules are reflected in the best practices for effective enforcement, but those practices recognize that very often extrajudicial enforcement is not feasible or may not be acceptable in a particular state. And as a result, we're going into somewhat more detail than the model law on secured transactions does with respect to judicial repossession and judicial enforcement, with some emphasis on expedited procedures. Finally, we're talking a bit about resolution of disputes with respect to enforcement. The last point that's being developed a little bit, and then I'll stop there, that addresses an issue that the model law doesn't address, is for those standards with respect to enforcement that cannot be waived by the parties, things like good faith and commercially reasonable practices. We're addressing the extent to which the parties can, in advance, perhaps reach agreement on certain standards that would measure good faith and commercial reasonableness, or identify certain practices in advance as being commercially reasonable, so long as that identification itself isn't beyond the pale. That's, again, still a bit of a work in progress. Well, I'll stop right here, and when we come back in the second round, I can address any other questions that might be there. Thanks very much.
Thank you very much, Neil. I'll just run to the next speaker, who is also online and who also does not need introductions in this context. Monica Canafoglia from UNCITRAL. She will answer the first question with reference to the UNCITRAL project on access to credit for SMEs. Monica, you have the floor. 10 minutes.
Thank you, Anna. I hope you can hear me well in the room and also online. Good.
There is a slight disturbance. Just 1 second. Maybe we can. So please go on, Monica. Sorry.
It's okay. Is that okay now?
Do you have a cell phone close to the?
Not at all. I actually had a test run right at 2 o'clock, 1:30, right before you started, and everything seemed to be working perfectly.
Yes, it was working fine.
No, I have nothing near me. No telephone, nothing.
Can you check eventually the cables?
I will. Does it go any better?
No.
No, but we can hear you. We'll tell you whether it will become too difficult to understand what you're saying. But we can write about it.
Otherwise, I can delegate my colleague Jay. That would be a perfect example of internal coordination. to say a few words on the project on access to credit for MSMEs. I will be very brief, also given the problems with the audio. The project, and again, good afternoon, good evening, maybe good morning, probably not to some of those connected. The project is the one that is supposed to complete the work of UNCITRAL on MSMEs. That work was started in 2013, and the focus of that mandate, of the overall work that has resulted so far in 3 legislative guides, is on removing the legal obstacles that MSME may experience throughout their life cycle. This current work will be the last of these guides, of those guides. It's not a legislative guide. It is a draft guide for the time being, and it is structured around the text on secure transactions that UNCITRAL has prepared over 20 years. The project is less, if I can say so, the draft guide is less, is a more general nature, less technical than the security guide, the secure transactions guide. It is based on quite expanded introductory part that introduces the issues that MSMEs need to face and the challenges that they need to face when they access credit, when they try to access credit, presents a certain number of sources of credit for MSMEs, and also aims at highlighting the different challenges that MSMEs may face. The core part of the guide, of the draft guide, is structured around legislative and non-legislative measures that states could consider or should consider to facilitate access to credit for small businesses. The part on the legislative measures, a core component of the section on legislative measures to support MSMEs access to credit is, in fact, relates to the MSME, to the secure transactions text prepared by UNCITRAL, as I said. First of all, the model law on secure transactions, then also references to the legislative guides, and then also references to the practice guide. I'm not going to go into details because the guide, the draft guide on access to credit, doesn't reinvent the wheel. It highlights the core aspects of the UNCITRAL work on secure transactions that are relevant and important to build secure transaction regimes that can facilitate MSMEs access to credit. And I think that here is the value of the guide. Although we all know, actually you all know better than I do, because many of you have worked on the topic of secure transactions for decades, that those texts prepared by UNCITRAL on secure transactions are applicable to MSMEs. Also, the guide that we are preparing, the guide that UNCITRAL is preparing, has probably the value and the merit of putting and stressing these aspects of the MSM of the UNCITRAL work on secure transactions. That is applicable and relevant and extremely important to facilitate access to credit for the small businesses. In terms of, and just one final word, in terms of coordination with UNIDROIT text and current work, we've just heard Neil Cohen talking about enforcement. Angelo earlier on has mentioned warehouse receipts, has mentioned factoring, and also William has mentioned, of course, extensively has discussed of the model law on factoring. All these texts have been several times referred and referenced to in the working group. The issue at the moment is that those texts are still being developed. And so for the draft guide on access to credit is kind of difficult to make final and definite reference to those texts. So that is still, if I can say so, it's an issue of coordination and also a little bit of a challenge that we have at the moment. I stop here. I hope that the sound was not too distorted, and I thank you for your attention and also for the patience with the audio.
Thank you so much, Monica. We could hear you well. There was this kind of robot-like performance, which was very interesting. Like a virtual rendering of Monica, but we could hear you very well. So thank you very much. Also for underline, I think one element which is connected to this gap filling role of the new instruments, and which is a particular focus on MSMEs, which is also the case, for example, for the model law on factoring, or later on for the model law on warehouse receipts. So this is also probably a point to be considered in the coordination, as well as a greater attention to how technology impacts secure transactions, and this because of the development of technology, which of course is something that was particularly evident later on. Of course, registers were already a development of technology, but we have the new technologies to consider. So I would like to go back to the second round, and I was formally authorized to go beyond 6 o'clock until 6 and a quarter. And therefore, we will try probably to not to do that completely, but maybe to take some minutes after 6 o'clock. And the second round of questions is probably a little bit more provocative, because the question would be, what is one or maybe two of the most important challenges that you see in finding coordination with the existing legal framework? And here, each of the participants can focus on any of the projects that were discussed. And each of the participants was given 7 minutes. Maybe you can try to be even shorter than that, if at all possible. And I would like perhaps this time to start with our friends from UNCITRAL, and particularly Jay, who will intervene for UNCITRAL on this particular topic. So Jay, you have the floor. Thank you.
Thank you. And I have a bit of a sore throat, so if you can understand, this is Monica. I'm trying to follow Monica's path about the voice being a little bit strange. So now, as the guardians of the model law on secure transactions, we've been following the projects at UNIDROIT, especially the model law on factoring, the digital asset project, especially the secure transactions part. But as Angelo mentioned in his opening remarks, we do not have a project on secure transactions yet. Now, the irony of that is that still, the small secretariat that UNCITRAL has, about half of the members of the secretariat is following the 3 projects at UNIDROIT. And I just wanted to mention that that is an issue that we face, in the sense that we have limited resources, but we have to continue to follow and monitor these developments. Now, in that context, I just wanted to say this is because we need to coordinate the new instruments, not only with existing instruments, but we need to coordinate the new instruments with the new instruments that we're producing. And therefore, this is the irony of actually trying to follow all of that. Now, that's why I wanted to kind of give you the perspective of UNCITRAL's lens on how we are looking at this project. Now, as to the access to credit project, Monica has mentioned that we're referring to the model law on factoring and warehouse receipts, Whether we can incorporate that into the guide is a question because it's not an existing text. So that's one question. Working groups 2 and 3 is kind of disrelated, and it's an irony that I'm actually servicing as the secretary for those working groups, but I'm following it because I used to work in the working group on secure transactions. But still, the technology-related dispute resolutions has an automatic enforcement related to it, so it actually relates to the enforcement project. We're also looking at dispute resolution in the digital economy, and we're looking at online platforms and how, if you're going to update the UNCITRAL technical notes on ODR, how that can be formulated and how that relates to possibly resolving disputes with regard to enforcement is related to the enforcement project. So that's kind of where there is a overlap. Now, of course, working group 4 that deals with electronic commerce, there's a lot more overlap because the model law on ETR has the notion of control. We need to ensure that the control concept is somehow preserved. We also need to preserve the technology neutral nature of our text. Now, on identity management and trust services, I see that Gary's proposal to have soul-bound tokens might actually have a relationship to that. So that's also where we need to keep an eye on coordinations. Now, that working group is looking at automated contracting, data provision contracts, which has an impact on the model law on factoring in the sense that the receivables arising from data services would need to be captured in the model law on factoring. So what we're talking about data provision contracts, we'll need to look into. We also have a task to prepare a guidance document on blockchains or DLTs, more as an enabling service providing services, but that's also related to the digital assets project. Now, working group 5 is kind of in the middle in the sense that it's new projects, the asset tracing and recovery projects is quite related to the enforcement project, and the applicable law in insolvency is also interlinked. Of course, when you talk about collective enforcement in insolvency proceedings and when you talk about bank insolvency, so there's a lot of more coordinations to be recalled there. So that is why, although working group 5 is not involved in secure transactions, it's closely following the 3 projects on secure transactions that's going on in UNCITRAL. And as Angelo mentioned, with working group 6, going to be delving into negotiable multimodal transport documents. It also would relate to the warehouse receipts project in the sense that we'll be delving into more substantive aspects of the negotiable instruments. So I think in looking at the broader picture, what's going on in UNCITRAL is very related to the 3 projects that is currently going on in UNCITRAL, and that is why we're following them all closely and the need for very close coordination.
Thank you very much, Jay. So some level of overlap is almost inescapable, and you are right that this creates the need for an attention and coordination between the 2 organizations and probably also other organizations that are involved in some of this work. So Jay was very quick in his dense presentation. So perhaps we can resume the order now and go to Will. What are the main challenges in your opinion?
Thanks, Anna. I'll be extremely brief as I've got half the model law and factoring working group here or online, so I think they might have more to add. But in addition to, sort of Jay pointed out, that the model law and factoring has overlap with broader instruments, not just the model law on secure transactions, particularly in relation to data receivables. I think, and of course, there are a million issues in that can arise in the implementation of these instruments. There are 2 that I would foresee in particular in relation to the model law on factoring and how it can fit into the broader framework, especially if it's trying to serve its purpose as an initial first step of reform to broader reform, and based on the model law on secure transactions. The first is in relation to the very few areas, and I emphasize very few, where the model law on factoring has diverged from the model law on secure transactions. In particular, one of these areas is in Article 8 on anti-assignment clauses. The model law on factoring provides for a complete override of anti-assignment clauses without preserving the right of a debtor to sue for breach of contract. This is a substantive difference, not a huge substantive difference, but this is a substantive difference to the model law on secure transactions. So if a state has implemented the model law on factoring, has implemented this complete override of anti-assignment clauses, at the point where they need to go on and then consider a broader secure transactions reform based on the model law and secured transactions, they'll need to make a policy decision. Do we keep the override? This is one example of a few other minute examples, but overall we have maintained, as Neil so aptly put, the exceedingly persuasive justification test in terms of trying to retain consistency between the two instruments. So thankfully, there's not a huge amounts of these issues that actually arise. The second point, very quickly, is what I noted earlier, which is the importance of having a complete, integral, harmonized registry. And I think there would be a risk that, let's say, an acting state implements the model law on factoring. They get up and running, they educate all their stakeholders, it comes into force, there's registrations, everything's working really well. 5 years down the track, they're looking at further reform. And I imagine there would be a tendency to say, let's not touch this. This is working really well. This legislation's in force. The registry is working in force. Let's consider our broader secure transactions reform sort of separately. And that obviously would cause some concerns if we had a proliferation of multiple rules, multiple legislation, and multiple registries. So obviously super close coordination with implementing agencies to explain the importance of integrating this first step with broader reform, especially in relation to registries. I would say if that's not done well, that could be a problem, but I'll leave it there. Thank you.
Thank you very much, Will. And we go back to the remote participation. I see Louise ready to enter into the discussion of the challenges. So Louise, you have the floor.
Okay, well, I mean, I'm not going to talk about all the challenges of digital assets or we could be here all night. So I thought I'd just mention a couple of points that I think have sort of come out of the discussion so far in relation to coordination in perhaps a slightly different sense than Will said. And that is this idea that all the instruments need to be consistent with each other. And I absolutely agree with that. But I think there are a couple of things we need to take account of when we're thinking of what we mean by consistency. Otherwise, it would be very difficult to draft anything and it would be very difficult to move forward. So to give you one example of something we might need to think about when we have a set of instruments and then we're drafting new instruments is basically the way things have changed over time. So, I mean, an instrument is drafted at a particular time and it will use words and concepts and so on that is appropriate to that time, however much it tries to reach into the future. It's always going to be the case. And so if there is an instrument coming later, to make it consistent may be not impossible, but to make it exactly the same may be quite odd. And I'll give you an example because I happen to be on the registration subgroup of the factoring model law. And we looked at the registration provisions of the model law of secure transactions. And we thought that just some of them, and only some of them, because the type of registry that was envisaged under the model law of secure transactions was either a paper registry or an online registry, some of the wording and some of the way it was put, we thought was not really very suitable as now we are going to recommend an electronic registry under the model law of factoring. And so we changed some of the wording to make it more appropriate where you would have a modern online registry. Otherwise, you will just perpetuate the sort of idea that a paper registry is okay when we basically think that a paper's registry isn't okay. So that's an example of how one might need to adapt previous text, even though what you're saying is basically consistent. I mean, the actual principles are exactly the same. It's just a matter of the detail. And then the other thing I'll say, and this might be much more controversial, is that I'm not at all convinced. Well, let's put it this way. It slightly depends what instrument you're drafting for a start. I mean, if it's hard law, that's one thing, and if it's soft law, that may be another. But certainly in soft law, and certainly when we're dealing with something like principles or something which is going to have to be, as it were, translated in various senses into domestic law, then it isn't, as far as I can see, it isn't absolutely impossible to have the same word meaning two different things in different instruments. One wants to keep the concepts as consistent as possible. But given that in a set of principles or very soft law, it's going to have to be translated into a different language quite often, but also it's going to have to be translated into a different legal system. And I mean, with our principles on digital assets, we are envisaging these are not going to be enacted. They're not drafted to be enacted. They're drafted to be consistent with a legal system that may implement them in many, many different ways, because it has to fit in with their property law effectively. And so it wouldn't be the end of the world, as long as it's defined properly, if a word that we used, such as, for example, control, wasn't exactly the same as the way that the word control is used in every other instrument that's ever been drafted by any international organization. Because it may well be that in relation to a particular situation, that you need a concept that is similar but not identical to the way it's used in a different situation. And therefore, it seems to me, and this is not necessarily anybody else's view, that as long as you draft it very clearly to say what you mean, that's much, much more important than having entire consistency. Otherwise, the alternative, and we did consider this with the digital assets, is to have a completely different word. We could have just used a completely different word, though I have no idea what that word is. It certainly couldn't be the word possession, because that's very much loaded with previous law and means something very different. And there didn't seem to be another word. But we could have just used another word. Because we've defined it, it has the meaning that it has, and it's a word that is defined to mean that word. And to give you another example, but if you like, there are different words in statutes, domestic statutes, all over the place, that where a statute will use the same word to mean something slightly different. And an example perhaps is money. So in many regulatory statutes, the word money is much, much wider than it would be in, for example, the Sale of Goods Act or a private law statute. So money laundering includes all kinds of different things. That is not sufficient to fulfill the definition of money in a private law statute. So I think that we do need to bear that in mind. And we particularly need to bear in mind the fact that this is not necessarily ever going to appear, this word, in a domestic statute, because a domestic law will enact it in using whatever words they actually want to. The thing that's really important is that the concepts are defined, and they're defined in an appropriate way for the type of the subject matter of the project that you're talking about. So it may be that that's a real challenge in many of these instruments to both keep the consistency of concepts and ideas, but to move forward over time, and also possibly to think of a word to mean something that is actually slightly different from that is used in a different context. And it may be that the only way that anyone can do it is to use the same word, but define them very specifically. Thank you.
Thank you very much, Louise, also for raising the point of terminology and deviation from internationally accepted terminology, because there is a particular need to do that, and the need, therefore, to have very good definitions of the words that are used. But as a comparativist, I'm always worried when words are used. The same word is used to mean different things. So the context has to be really very well explained, which is what actually I think happens for this particular project. So I would like to conclude this second round with Neil, who has been waiting patiently for his challenges part. So Neil, you have the floor.
Thanks very much, Anna. And I apologize in advance if there are any interesting sound effects during my remarks. There's a thunderstorm going on in New York right now. And if I'm lucky, when I state my most important views, they'll be emphasized by a peal of thunder in the background. I think that the biggest challenges in this area are not substantive coordination. Once we commit ourselves to the various instruments being consistent with each other, and we commit ourselves to following that ideal, as long as people know the different instruments, they can prevent inconsistencies. Rather, I think the biggest challenge is what we mean by coordination and consistency, and the method by which project A states things and chooses the questions it wishes to answer and answers them in a way that's consistent with other projects. And I think the heart of this goes to recognizing that these different projects exist, not just to be busy work, not just to replicate what has been done before, but to approach the question from a different angle or at a different time, as Louise pointed out, or with a different audience. And in many ways, I think the two key differences we have to respect in coordination are differences in the nature of the audience and differences in the nature of the instrument that's being prepared. Take the enforcement project, for example. Unlike the model law on secured transactions, which by its very nature assumes a state that wishes to have a comprehensive reform of its secured transactions regime, the enforcement project does not take that as a starting point. And indeed, some of the greatest value it will add will be in states that are not thinking of doing secure transactions reform, but might yet advance the ball a bit in their economic effects of their secure transactions regime by having a modernized and an efficient and effective enforcement regime. And so how to state rules, how to characterize them, what angle to approach them from has got to be audience sensitive. The end substantive result, we all want to be as coordinated and consistent as possible. But again, the approach to stating it must differ, very often must differ in light of the audience. Second thing, that's different, and we've heard some references to this already, is the nature of an instrument. A mandatory type of instrument, like a convention, where if a state is to join it, it is bound essentially by every word of it, requires a different type of approach to drafting than something like a model law, which is designed, again, to be a comprehensive framework, perhaps, but one that each state can adapt to its needs, both in vocabulary, as Louise suggested, but also in substance. And finally, some of the softer instruments, like best practices instruments, their most important contribution very often is their persuasiveness, their guidance, rather than the particular words they use. Coordinating one instrument that is in the form of a model law with another instrument that's in the form of explanatory guidance is an art rather than a science. But I think the starting point is avoiding inconsistencies, but that's not the ending point. The real hard work comes in figuring out the clearest and most effective way to adapt principles that were developed in one context for use very often in a very different context. And that's very often what the hard work of the various working groups is. Thanks.
Thank you so much, Neil. We have reached 6 o'clock, but there is still time for perhaps a couple of questions or comments if you still have the energy after this very rich afternoon. So I don't see any online. I don't see hands raised here in the room. Any comments, additional comments from the panel? No. So if this is the case, then I think we can call it a day. And thank you very much to the panelists, and please join me in thanking them for excellent presentations and excellent questions and concerns that will go on also tomorrow. And have a lovely evening. And we'll see you tomorrow at 9 o'clock. I think everything will start again.